I think the law offices of Daddy and Master got a little education in what a proper pleading looks like. I am somewhat jealous. In California, you can't do this and have a big old title up there. See how they did this part right here? I mean, that looks really nice. In California, it has to be the attorney name and bar number. And then under that, you could do just typed out. Like, I don't think you could use like a picture like that, but it's just got to be typed out. Your law firm, address, phone number, fax, email, and then attorney for whoever. So that looks really nice. And I wish we could do that in California. I don't know why I wish we could do that in California, but I think it looks really nice. And also in California, it's the Superior Court of the state of California, and then whatever county. So they've got it kind of upside down here. But other than that, there you go. So this is Law Offices of Daddy and Master versus the Maricopa Unified School District. This is what a pleading is supposed to look like. The fancy language up at the top you don't really need. Now comes the defendant, Maricopa Unified School District, and responds to the special action complaint filed by plaintiff Chauncey Hollingbury, plaintiff as set forth herein. So the way this is going to be laid out is there's going to be a question, which is going to be numbered, and then there's going to be an answer to the question. They're either going to admit or deny or some combination thereof, each element of each question. So question number one, plaintiff reached out to the Maricopa Unified School District Custodian of Records, Tom Beckett, HR Director, on May 7th, 2018. Answer. Admit that plaintiff first made contact with the district on May 7th, 2018, but deny all characterizations thereof. On May 7th, 2018, plaintiff telephoned the district office twice. On May 9th, he telephoned the district office 9 times. Plaintiff also communicated via email with Mr. Beckett beginning on May 7th, 2018. Number two, plaintiff requested the following records. These number twos, these are what Chauncey is stating. These are the statements of fact that the Maricopa Unified School District was able to glean from that turd that Chauncey wrote. Plaintiff requested the following records. All emails and any other electronic or paper records which mention Chauncey or Chauncey Hollingbury, all internet records of any social media sites accessed by Jamie Morano, who also goes by the name of Jamie Lambert, employed at the Santa Cruz Elementary School from January 1st, 2018 to May 8th, 2018. Jamie Morano's or Lambert's employee picture. I've seen guys go through great lengths to get a girl's name and phone number and picture and stuff, but this is a little creepy. I'm just going to go there. This is a little creepy. Answer. Admit to the contents of plaintiff's public record request. Oh, by the way, Chauncey, she's married, dude. Just let it go. Admit to the contents of plaintiff's public record request. At the request of Mr. Beckett on May 8th, 2018, plaintiff completed the district form KDB-E to make his public records request. 3. Tom Beckett responded on May 9th, 2018, providing 3 emails and responding the district would provide no more. Answer. Admit that on May 9th, 2018, Mr. Beckett provided to plaintiff the district documents responsive to his public records request. Mr. Beckett informed plaintiff that the records produced were the only records maintained by the district that were responsive to his public records request. Plaintiff filed this special action on May 10th, 2018. Number 4. Tom Beckett also refused to detail what records exactly were being denied and the reason. Answer. Denies false. Mr. Beckett did not refuse to do anything. The district further states that the district is not required by Arizona law to provide an index of records withheld and the reason the records have been withheld, as the district is not an agency as contemplated by ARS 39-121.01D2. See also ARS 41-1001 subsection 1. This is 39-121.01D2. If requested, the custodian of the records of an agency should also furnish an index, etc. And then 41-1001 Agency means any board, commission, department, officer, or other administrative unit of this state. I believe the Maricopa Unified School District is a county unit. So I think that's where they're drawing the distinction. Agency does not include a political subdivision of the state or any of the administrative units of a political subdivision. So there's probably case law out there that these attorneys are aware of. Again, it's very hard for me to find case law out of state that's pertinent to a state statute for a state that's out of state. The way you find it is you go to the law library, you look up your state's statutes, because those are going to be in there. They're going to be annotated versions of them. You flip open to the particular statute you want to figure out what cases have kind of defined the various terms of. You look those up, you read them, you figure out how they interpreted everything. But if you don't have those books there, it's really hard to figure it out. So like the California law libraries, or at least the ones that I have access to locally, don't have Arizona annotated statute books in them. So there you go. Or Texas for that matter. I am lacking both. Number 5, Tom also refused to provide the district's general counsel contact information. Answer, denies false. The district asked plaintiff to provide his attorney's contact information, and it would have its attorney contact him or her. Plaintiff did not respond. Thereafter, on June 5th, 2018, when plaintiff was found in the private office section of the district office without permission and videotaping, he asked the superintendent, who was escorting him to the exit, for the name of district counsel, and she provided it. And she did. You can watch the video. Chauncey Hollingberry likes to give copyright strikes, absurd copyright strikes, so I won't be putting it up. But you can see it right there. And I'll put a link to it in the description as well, since you obviously won't be able to link it. Number 6, plaintiff is requesting a court order to compel this public entity to comply with the Title 39 Public Records Act. Answer. The district has provided the plaintiff with all records responsive to his public records requests that are maintained by the district pursuant to ARS 39-121.01. That's this one. The district is required to maintain those records, reasonably necessary or appropriate to maintain an accurate knowledge of their official activities and of any of their activities which are supported by monies from the state or any political subdivision of the state. That's 39.121.01b. The district has complied with its legal obligation and has produced those records to plaintiff. The district does not maintain records of district personnel internet access, nor does it maintain photographs of its employees as a single public record. Arizona's public records laws do not require an agency to tally and compile previously untallied and uncompiled, or uncomplied, I think it's supposed to be uncompiled, information or data to respond to a public records request. See the American Civil Liberties Union of Arizona versus the Arizona Department of Child Safety. There is no requirement to create a new record that compiles. I think they mean compiles. Let's see if we could find this case. Boom. All right, so we're looking for uh-oh, they had a typo. Naughty, naughty. There's a lot of that in law, by the way. People are too lazy and they rely on Word to tell them if a word is misspelled. And Word only tells you if a word is misspelled, not if it's the wrong word or if it auto-corrected to a different word. So they should have caught that. That's bad. Plaintiff is requesting fees as allowed in 39-121.02 subsection B. Wait, what? Oh, yeah. Okay. And this one. The court may award attorney fees and other legal costs that are reasonably incurred in action under this article if the person seeking public records has substantially prevailed. Answer. Although plaintiff identified himself in his recent court filings as law offices of Daddy and Master, future, he is not an attorney licensed in the state of Arizona and is pro per in this matter. Plaintiff is not entitled to attorney's fees as he has incurred none. Even if plaintiff were to retain counsel, this action is frivolous and plaintiff will not prevail as required by ARS 39-121.02b. The defendant, Maricopa Unified School District, has a governmental presence in the county of Pinal, 44150 West Maricopa, Casa Grande Highway, Maricopa, Arizona, 85138, which is the custodian of records. Answer. The district does not understand the allegation. However, the district admits to the jurisdiction of this court. Number 9. Pursuant to ARS 39-121.02, subsection A, B, and C, the court has jurisdiction to hear this special action. Answer. Deny that ARS section 39-121.02 is jurisdictional. However, the district admits to the jurisdiction of this court. It is pedantic, but it says that they may appeal the denial to a special action in the Superior Court. It's pedantic, but they are technically correct that it's not a jurisdictional question. Okay, number 10. Plaintiff has been harassed, threatened, and intimidated by multiple government employees, including Mark Schoenberger of Cave Creek Unified School District and Jamie Morano of Maricopa Unified School District on government time. Answer. As to Mr. Schoenberger and the Cave Creek Unified School District, the district has no information on that allegation, nor the authority to respond. As to Ms. Morano, a teacher employed with the district is aware that Ms. Morano and plaintiff have had previous interactions unrelated to district business or to Ms. Morano's employment with the district. Upon information and belief, plaintiff hosts a YouTube channel formerly identified as Dragonfire Auditing and now identified as Law Offices of Daddy and Master. As a public social media site, anyone can comment on plaintiff's videos, and there are in fact hundreds of comments from members of the public to plaintiff's posted videos. Upon information and belief, Ms. Morano may have commented on plaintiff's social media site, but not in her capacity as a district employee. Number 11. Plaintiff traced the harassment back to Cave Creek Unified School District and Maricopa Unified School District. Answer. The district is without information to respond to this allegation and further states that this allegation does not seem to have any bearing on plaintiff's request for public records from the district. Yeah, it doesn't have any bearing on it. Number 12. Plaintiff, through a Public Records Act, was able to determine Mark Schoenberger was using government equipment and time to harass the plaintiff. Answer. The district is without information to respond to this allegation and further states that this allegation does not seem to have any bearing on plaintiff's request for public records from the district. 13. The defendant is aware Jamie Morano, a school teacher at Santa Cruz Elementary School, is participating and a ringleader behind these actions. Answer. The district admits Ms. Morano is a teacher for the district and denies the remainder of the allegations in this paragraph as nonsensical. 14. The district is refusing to provide public records indicating Jamie was using government time and equipment and a personal phone to facilitate this harassment. Answer. Deny. The district did not refuse to produce records to plaintiff. The district does not maintain the records as requested by plaintiff. Further, the district does not have access to nor authority over any records related to Ms. Morano's use of her personal phone. Dated 19th of June 2018, Udall Schwartz PLC, signed by Aaron H. Waltz. It was co-written by Kimberly R. Davis. Kimberly R. Davis is probably an associate attorney. Walls is the lead, and then Kimberly R. Davis will be the person who actually wrote this, and then Aaron Waltz signed it. And they're attorneys for Maricopa Unified School District, and there is the certificate of service. So this, law offices of daddy and master, is what a pleading should look like. In form, in function, concise, to the point, talking about facts. Arizona is a fact-based pleading state. You need to plead facts, not legal conclusions. Thanks for watching. Have a great day.